we were discussing the debt recovery laws and procedures. So we have to start from here, the Commercial High Court. The Commercial High Court is established under the Commercial High Court of Province Special Provisions Act number 10 of 1996. This special courts was introduced to the country in order to have a procedure to hear commercial transaction disputes. That was the idea behind this, because as you know, when we go to district court has a wide power jurisdiction to hear any type of civil action, from family matters to land disputes, commercial, any matter will go to district court, irrespective of the value of the transaction and also irrespective of the type of the transaction. So that was the position before 1996. So however, the government and there was a discussion in the industry because of this, the number of cases are high in district courts. The commercial matters are getting delayed, and because of that, the banks and other institutions, they cannot recover their loans through court procedure. So therefore, they want to expedite the matters, and they make a representation to the government at that time. And the government then decided to have a special court system or court houses for this purpose. So that's why in 1996, this high court, special high courts, they introduced to the country, which is called commercial high courts. So what is the jurisdiction of the commercial high court? What kind of cases that the commercial high court can hear and decide? So basically, I have given here some of the main cases that the commercial high court can hear. Those are commercial transaction, including banking, insurance, export and import, mercantile agency, and mercantile usage, when the claim is over 20 million rupees. So this is very important. If the claim or dispute is based on the commercial transaction or banking, insurance, or any type of export import matter or mercantile agency matter, if the value of the claim, say for example, bank has granted a loan and the total dues today is over 20 million, right? In a case like that, based on the value and based on the transaction, since it is a banking transaction, it is coming under this. So the case has to file in commercial high court, not in district court. So that is the one jurisdiction that commercial court exercise. Then the second type of cases that the commercial high court here is admiralty cases. Admiralty cases means, you know, that when there is a dispute arisen between a shipping company and a ship, or in the crew of the ship, or whatever, something related to maritime matter. So that matter also can refer to the commercial high court of Colombo. So that is the second type of cases that commercial high court can decide. Then the third one, intellectual property and trademarks dispute. This is another important area where, you know, that there can be disputes among companies or even individuals, among individuals, with regard to intellectual property and trademark. For example, we say someone has invented a new machine or something, and he register that machine or the technology under his name. He get a license for that. So then, if someone without his permission use the technology or the machine for the commercial purpose, that is an infringement of intellectual property right. So that type of cases also can be referred to the commercial high court, irrespective of the value. Irrespective of the value. Then the other type is trademark dispute. Trademark dispute means, if I give an example, we say, we'll take a real example. We take Melbourne and Munchie. So both they are in the same the field, and they produce same commodity, biscuits, right? So they have basically ideal product. For example, we say we have cream cracker, Melbourne cream cracker, and Munchie cream cracker. Both are same general product. Generic product is cream cracker, but they have different logos and their trade names. And Melbourne, they use red color packing, and Munchie, they use yellow color packing. So for example, we say now one company manipulate the wrapping of the other company, that is an infringement of trademarks, or even a trademark or packing, or this, everything covers under this. So then it's a dispute, because then the customers get confused. They will mislead by the packing and the logos that they use. So therefore, in a case like that, it's a trademark dispute. That also can be referred to the Commercial High Court of Colombo, irrespective of the value of the trademark dispute. Then the other types of matters that we can refer to the Commercial High Court is enforcement of arbitration awards. That is, when we refer a matter to the arbitration, under the arbitration procedure, at the end of the inquiry, arbitration inquiry, arbitration body gives a award. That is a judgment. That is special name. There's a special name for that. We call it award. Then to enforce the award, because the arbitration body does not have the authority to enforce the award, even though it has the power to give an award, they can't enforce the award. So therefore, it has to be referred to the Commercial High Court or High Court, and get an order from the court to enforce the arbitration award. So those are the type of cases that we refer to the Commercial High Court. Basically, even though that this Commercial High Court were decided to have in every province, only some of the provinces that we have Commercial High Court. Basically, we have Commercial High Courts in Colombo. In other areas, we can't see the Commercial High Courts. However, certain areas that the High Court itself practice the civil jurisdiction also. So therefore, these Commercial High Courts are empowered to hear civil dispute, especially commercial disputes, under the Act number 10 of 1996. Then we will go to the next slide, that is the procedure at Commercial High Court. What is the procedure that we follow at the Commercial High Court? You can see the procedural wise, it is similar to the District Court regular procedure. Similar to the District Court regular procedure, not summary procedure. So therefore, if someone thinks that the procedure adopted in the Commercial High Court is a short version or summary version of the normal procedure, that is wrong. Actually, the regular procedure applies here. However, as my experience, the Commercial High Court trials normally won't drag that much, because the judges are trained for that cases. They have the knowledge, commercial knowledge, and they have the banking knowledge. So they can basically here and give the decisions compare to a district court in speedy manner. So the procedure, the first step of the commercial high court procedure also, we send a letter of demand demanding the money. So to go to commercial high court, we should have a claim based on a commercial transaction or banking transaction or insurance. So the claim that we make or what amount that we demand from the other side, it has to be over 20 million now. Initially, when the commercial high court started, it was 20 million. Sorry, it was 2 million. Then it was increased to 5 million. Now it has been increased to 20 million. So if the claim is below 20 million, so you have to refer the matter to the district court. If it is over 20 million and above, we'll go to commercial high court. So therefore, demand is very important. When you demand the money, if the value is over 20 million, and if it is based on the commercial transaction or a banking transaction, so then you know that the next step, you have to file action in commercial high court. So after sending the letter of demand, we normally give 14 days to the customer, to the borrower, to pay the entire amount that we demand together with the interest. So after sending the letter of demand, next what we do, we have to file action in courts. So then filing of action means here in the commercial high court also the same, the procedure that we adopt as district court. We file the plain and marked documents and the proxy. Proxy is the document that we give the authority to the lawyer to appear on behalf of the company or the individual. Then we file our plaint. Plaint is the story that we have to say to the courts, that is in a written form. So then after that we have to annex whatever the documents to support our plaint. We have to annex to the plaint as annexures. So in a commercial transaction, it is very important to annex all necessary commercial agreements, reminders, statements, instruments, all these things as a part and parcel of the plaint, because if it is not a commercial transaction, so judge can reject the plaint. If it is not a commercial transaction, judge can refuse the plaint. So refuse to accept the plaint. So at the first instance, we have to satisfy the judge that the plaint that we present to court is based on a commercial transaction and the value is over 20 million. For that, we have to show the case. We have to elaborate the case of plaint to show that it has been arisen, the claim has been arisen out of a commercial transaction. Then the next one is jurisdiction and prescription. Jurisdiction means the area where we can file action. So as you know that if it is a commercial transaction and if the parties are residing, a transaction has happened in the Colombo, so that matter, and also if the value is over 20 million, then the matter has to refer to the Commercial High Court of Colombo. Again, I will repeat, if the transaction is based on a commercial transaction, and if the transaction or the agreement entered in was happened in District of Colombo or Western Province rather, then further, if it is a commercial transaction over 20 billion, then we can file action in District Court of Colombo. If it is a transaction, commercial transaction, if it is over 20 million, but if the transaction has happened or the agreement that we entered into was happened outside the Western Province, yes, that means in another province. So that matter we have to refer to the relevant district court, because the commercial high courts are not established in the other provinces. So then firstly we have to decide where we are going to file the action. that is the jurisdiction. So then after deciding the jurisdiction of the court, that means once we decide the courthouse where we are going to file action, then the next thing that we have to look into is the prescription, whether we are in the prescriptive period. So I will explain what prescription is. Prescription is, under the law, there is a time period given. Within that period that we have to file our case. If you fail to file the case within this period, what will happen? It is called then prescribed, expired. So thereafter you can't file action, even though your matter is big issue based on a big value. So still the matter is prescribed. So therefore that you can't file action. So then it is very important to the bankers and also everyone in basically whatever the action that you have to take the action within a period, the prescribed period. So the prescribed period for commercial transaction based on written agreement is 6 years. Commercial transaction based on a written agreement, the prescription period 6 years from the default. From the date of the default, 6 years, within 6 years, we have to file action. When we say 6 years from the date of default, we have to calculate, or we have to count the 6 years from the last payment. From the last payment. So therefore, from the last payment of the customer or the borrower. So therefore, it is very important. So if you have a customer who has already defaulted, that remember that your prescription period has now started. It is ticking now, right? After 6 years, that will be over. Then you can't file action. So therefore, please remember, whatever the action that you want to take to recover money, that you have to take it immediately. Then if it is a commercial transaction where the value is over 20 million, but your transaction is based not on a written agreement. Now, for example, we have cases where merchants, they sell wholesale goods to their dealers, sometimes without any written agreement. So that is a practice that we see basically in Dam Street and Peta. So they just give or they supply goods on credit to their retail customer, retail businessmen. Then the problem is, it's not a written agreement, though it is a commercial transaction. It's not a written agreement. There's no written agreement. Then if the value is over 20 million, so you have to file action within then 3 years, not 6 years. So because you don't have a written agreement. Then that is about the prescription. Then after filing the case, the court will issue summons to the defendant through the fiscal. Then the fiscal will go and serve the summons. If it is a company, it will serve to the company registered address, or if it is an individual, it has to serve to the individual personally. So that is service of summons. After service the summons, the defendant, the borrower, has to come and file their answer. Proxy and answer has to be filed by the defendant. So basically, filing a proxy and answer, once he filed the answer, he will answer to the plain. Basically, whether he will say that whether he is going to accept the plain, the amount that we claim or not. So in normal cases, normal circumstances, defendants comes and they deny that they have to pay the amount mentioned in the plain. So that is filing of answer. After filing the case, after filing the answer, then the matter has to fix for pre-trial. Matter fixed for pre-trial. Then before pre-trial, 1 month before pre-trial, the parties, that is the lender, the company or the bank, and the borrower, the defendant, both has to file their a list of witnesses and issues. So after that, the pre-trial comes. At the pre-trial, the parties has to decide what are the admissions that they can, what are the things that they can admit. Now, for example, if banks and the customer, if both can accept that the bank granted the loan and the customer obtained the loan, that can be recorded as an admission, so then you don't want to give evidence with regard to that matter because it is admitted. And likewise, whatever the admissions that you can admit, both parties, that can be recorded as admissions. Then the balance that we have to raise as issues of the case. What are the issues? Means what are the questions that that we have to find answers at the trial. So that is called issues. So then at the pre-trial, that we settle the issues, admissions and issues. Then afterwards, the matter will fix for trial. Matter be fixed for trial, and at the trial, the first plaintiff has to start the case. If it is the bank or even institution, lending institution, they have to start the case by giving evidence in courts. So the bank officers or the officers of the financial institution has to give evidence first, and also they have to produce whatever the documents available with them to support their case. So then after the plaintiff case is finished, then the defendant, that is the borrower or maybe sometimes guarantors, has to start their case. At the trial, I think I last week also explained this. At the trial, the first part of the trial is examination in chief. Examination in chief means that your lawyer questions you, and from you he will get the story out, and whatever the story that you have to tell, you have to present it to the courts by way of answers and questions and answers. The questions your lawyer will ask, then you have to reply to those questions. So that is called examination in chief. After the examination in chief is over, then the defendant's lawyer can cross-examine the witness. Cross-examine the witness. So at the cross-examination, that the defendant's lawyer will try to get the necessary, will get the important answers which in favor of him from you, from the witness. So that is called cross-examination. After the cross-examination, then again your lawyer get a chance to do a re-examination. Re-examination means he comes and he asks certain questions again from the witness, that is to verify or explain certain questions, or rather certain answers that you gave during the re-examination, to clarify those things or to rectify those things that the re-examination is given. So your lawyer again will re-examine you by asking question, and you have to answer to that. So then after that, then the defendant has to start their case. Defendant case also like that. Then first defendant gives evidence, then the plaintiff lawyer cross-examine him, and his lawyer, the defendant's lawyer, again re-examine. Likewise, that whatever the number of witnesses that you have listed in the list of witnesses that you can call to give evidence on behalf of you, and also defendant can call evidence as per his list to prove his case. So then afterwards, after the defendant's case is over, then the matter then fixed for a written submission. Written submissions. Written submissions means the both parties, they have to summarize their case and prepare a written submission. And also in the written submission, whatever the legal principles that you are relying on, you have to mention in the written submission, and also uh, whatever the judgments, previous judgment that you are relying on, that you have to quote in your written submission. So after then both parties have to file written submission on on a particular day. That is the date given for written submission. After filing the written submission by the both parties, judge will fix the matter for the judgment. So then after that, after judgment matter is fixed for judgment, the judge will go through the evidence that you give, which is recorded, and also the evidence that that the defendant, the borrower gave, both will go through by the judge, and also documents that you annex with your at the time of your examination also will take into consideration by the judge. So likewise, then defendant's evidence and also defendant's documents also will consider by the judge. Then after analyzing the evidence of the witnesses, and after analyzing the documents that marked by the witnesses, both parties, and also after considering the written submission filed by the plaintiff lawyer and the defendant's lawyer. So based on these three, evidence, documents, and written submissions, judge will pronounce the judgment. Judge will pronounce the judgment. So therefore, it is very important. You have to remember the judgment is depend on three things. That is the evidence that you gave in courts, then the documents that you produce to courts, and then the third one is the written submission. So therefore, if you are representing the bank to give evidence, remember your evidence is crucial. Based on your evidence, that the judge will give his decision. So therefore, it's very important to be ready, be well read before you go to give evidence. You have to read all the documents, necessary documents, and see your security documents. You have to thorough with before you give evidence. So then thereafter, based on those three, judge will pronounce the judgment. Judge will pronounce the judgment. So then we say the judgment is given in favor of the bank. So that means judge has given an order that the bank can recover the amount mentioned in the plaint from the witness. That is the judgment. So then the next step is, if it is in favor of the bank has to execute the writ, execute the decree. That means the bank now has to recover the money. So the fiscal officers of the court can seize the goods of the borrower. Seize the goods of the borrower, that is the defendant. They can seize the goods. They can seize household items, electric items, whatever, but certain things that they can't seize. And also there is a provision that we can seize the defendant's salary also. That is also possible. So then the goods will be seized by the fiscal. Then afterwards, that seized goods will be auctioned at a court auction. It's a public auction. So then from the money that we received from the auction, that we can recover our loan or whatever dues, and also the expenses occurred to the bank from the proceed. We can recover that from the proceed of the sale. So that is the procedure adopted in commercial high court, similar to the district court procedure. So up to now, with regard to the commercial high court procedure and also commercial high court structure and jurisdiction, If you have any questions, now you can ask. Do you have any questions? Right. Okay. So since you don't have any questions, then I will go to the special laws to facilitate recovery of debts. So that is the topic that we have to discuss today. Special laws to facilitate recovery of debt. When we say this topic is very important, because the topic says the special laws. We have to study what are the special laws available to us to recover dues or debts. So when we say special laws, there is a general law. What is that? If it is a transaction below 20 million, you go to district courts and file action, and you follow the procedure, and you get the money. So if it is a commercial transaction over 20 million, you file action against the customer in commercial high court, and you follow that procedure that we discussed, and ultimately you seize the properties and you recover money. So that is the regular normal procedure. So apart from that, in this industry, there are few special laws introduced by the legislature, the government, to expedite the debt recovery process. So that is the idea behind the government pass these special laws, to debt recovery special laws, in order to expedite the recovery processes of the banks, because otherwise it will affect the banks, the economy, and also that has a effect the economy of the institution will it has a effect on the national economy. So therefore, to have a healthy national economy, it is always needed to have a speedy debt recovery method. That's why the government introduced this new debt recovery laws. Under this, first, next slide is, first we have to understand, before we study special laws, what type of security or what type of facilities that we grant to the customers, that we have to first understand. The bank facilities that we grant to the customers. Here that I have given two columns comparison about secured facilities and unsecured facilities. In my left hand side, the secured facilities are given. In the other side, unsecured facilities. Some examples I have given here. Secured facilities, I have given examples. The facilities secured by the guarantee bond or mortgages, leasing, hire purchase, and pledge. Those are the facilities that we normally consider as secured facilities. And there are other facilities also that you can, if you remember, right? So from the other side, unsecured facilities or clean facilities, what are the examples? So first example is casual overdraft. Casual overdraft is the first example. So what is casual overdraft? What is casual overdraft? Can a bank explain me how you give a casual overdraft facility to the customer? Can someone respond to me? What do you mean by casual overdraft?
Overdraft.
Yes.
The overdraft accommodated without any document being exchanged with the borrower.
Okay, very good. Right. So may I know your name?
Asela.
Asela. Okay, Asela from NTB. Asela, now you said yes. Your answer is perfectly correct. You said without any document, without any documentation, you provide the customer to overdraw the facility. So that because the managers they have given an authority, a limit. Within the limit, the bank can pay customers checks even though the money is not sufficient by overdrawing the account. That is called casual overdraft. Now the question is, when we recover the casual overdraft, we basically recover not only the capital amount that they took, but we charge interest also. Not only that, if you remember the casual overdraft and also one other overdraft, we charge interest on interest or compound interest. So, so and also the interest rate. What is the interest rate applicable in a casual overdraft? Asela, can you answer to that question? What is the rate where the customer has agreed to pay that rate? Do you have any idea?
That is generally in the terms and conditions of account opening.
Uh,
We say that for overdraft we charge the rate applicable. In time to time it may vary.
yeah.
So currently it's 18 now with the recent reduction.
Yes.
There is no specific reference to the interest rate in a casual overdraft.
Right. Okay. So very good, Asela. Right. So you said when a customer open account that we give him a terms and conditions which is applicable to the account to maintenance of account. So therefore, in that terms and condition, there is a clause to say if you overdraw the account, that the bank will charge interest at the prevailing rate. So that those are the words that we have used. So then the prevailing rate can be changed depending on the market condition. It varies. So that is one thing. And the important thing is there is no written agreement. Though we say that we have given him terms and conditions, we don't have an agreement. We don't have an agreement between the customer and the banker, which in written form that he has agreed to pay 18% or 28% interest. There's no written agreement basically. So then what I want to tell you here is this is a facility, the casual overdraft is a facility we give without a written agreement. Then something should come to your mind, that is prescription. If the customer default within 3 years, that you have to file action. So therefore you have to carefully monitor from the last payment of the customer, prescription start. So what will happen if it is a branch customer? If normally the overdraft are handled by the branches, so they provide the branches. I mean the ODs are provided by the branches. So then if you can't recover the money and if you keep the file in the branch without taking any legal action, so after 3 years, that remember that you can't file action, then you have to write off the account and forget about the debt. So therefore, branches, bankers, when you are working branches, that is very important. Overdraft, casual overdraft, that you have to monitor. However, by court, it has been accepted. The bank can charge, even a written agreement, bank can charge the prevailing rate as that can be decided by the bank based on the prevailing market condition. The bank can decide the rate of interest rate for casual overdraft. And also there is another thing that the court has accepted under the law, that is the bank rather the customer is obliged to pay the total overdraft plus interest when the bank demands the total amount the customer has to pay. That is another feature of casual overdraft. And also bank can charge compound interest. Interest on interest also allowed. Only for the overdraft that is allowed. No, not for short-term loans or any other the facility except overdraft. That we can't charge compound interest. That you have to remember. And TOD, the second type, TOD means temporary. We give them customers. We give them a limit, temporary limit, where the customer can overdraw his account within the limit over a period of time. So that is again a bank's decision, bank's discretion. So without any agreement, without a written agreement rather, the banks provide this facility to the customers. Then short-term loans also we have seen without written, some, not all banks, some banks without any documents, documents in the sense without any agreement, without any written agreement. So they provide short-term loans also. Credit card is another important product that we have, which is fully unsecured, not secure, right? So we provide an instrument called credit card, where the customer with a limit. So then the customer can use that card to purchase services and goods from merchants. So for that amount that he owe to the bank, he gets a period to pay, and also the bank can claim interest on the delayed payment also. So for the credit cards, we normally don't take securities, we don't take guarantors, we don't take any property mortgage or anything. So credit cards also it's a clean base facility, but normally we enter into agreement, credit card agreement, when we are granting credit cards. In short terms also, short term loans also, we normally sign short term loan agreement, but some occasions we take securities, some occasions we don't, depending on the credibility, creditworthiness of the customer. We decide whether we are going for a security or not. So do you have any questions from this part? If you have any questions that you can ask, or otherwise I will go to the next slide. That is debt recovery. So money recovery action, regular action on a guarantee bond. So we will take one situation where we have granted a loan to a customer based on the personal guarantee of another person, guarantee of another person. It's a secured facility, and the customer now has defaulted. Customer has defaulted. So what is the procedure that we have to adopt now? So that is the question. The procedure is, it's a court procedure. Under the court procedure, that we have to file a regular action against the borrower and also against the guarantor. So that's the procedure I have given here. It's the same procedure, regular procedure, that we already explained, that we already discussed. District court regular procedure. First, we send the letter of demand. We have to send the letter of demand to the borrower, and also we have to send a letter of demand to the guarantor. It is very important when you are sending a letter of demand to the guarantor, you have to demand the money on the guarantee bond, because the loan agreement is a separate agreement that the bank enter with the borrower. Guarantee bond is another agreement where the bank enter into the guarantee bond with guarantors. So two different agreements. So therefore, when you are sending the letter of demand, you have to demand the money from the borrower based on the loan agreement, and you have to demand the money from the guarantor based on the guarantee bond. So that's a different uh, one special feature of the letter of demand under the guarantee bond. So then afterwards, file action. File action means the bank, we give 14 days notice to the guarantor and the borrower to pay the money in our letter of demand. And if it is not met, then we file action. We file action against the borrower and also against the uh, guarantor. We can, as per our documents, we can file action together against the guarantor and also against the borrower if it is a joint and several guarantee. What is joint and several guarantee? We are going to discuss under the new next topic, that is securities, that we are going to discuss later. So if it is a joint and several, for the time being, remember, if it is a joint and several guarantee, that the bank can file action against the borrower and also against the guarantor in the same action. Simultaneously we can file against the both parties. Then serve summons. So summons will serve to the borrower and the defendant. Then the both can file their answer. Then the process is same as we discussed previously. Once the judgment is given against the borrower and also against the guarantor, then we have to execute the writ, execute the decree. So then there is a different there again. In the previous case procedure, as I explained to you, so you go and seize the properties of the borrower. But here, since the judgment is given against the borrower and also against the guarantor, borrower and the guarantor, the fiscal can seize the goods of the borrower and also goods of the guarantor. So basically, we can seize, compared to the previous one, we can seize a large number of household items and other things if you execute the writ against the borrower and also against the guarantors. That is one advantage we have here. Then after seizing the goods, properties, so rather household items and other things by the fiscal, then those will be auctioned at a fiscal auction. So from the proceeds that we receive from the fiscal auction, that we can use that money to recover the dues from the borrower. So that is the procedure that we adopt against the borrower and also against the guarantor. So if you have any questions or any area that you couldn't understand, I can explain to you further. So do you have any questions up to now?
So I have a question.
Yes.
When you go into the according to guarantee bonds cases,
Yes.
if we going to execute the writ,
Yes.
should we go only for the movable properties, not for the immovable properties? I want to know that.
Right. Okay. Very good. It's like this. I will explain. Right. If it is a mortgage, right? If it is a mortgage, then you have. Then I will compare these two. We are going to discuss next one. We are going to discuss about the mortgages. But since you asked this question, I will explain to you. If basically, if it is a property, if it is a money recovery action, that we can seize any property of the borrower and the guarantor except for certain items. Certain items means that you can't seize the clothes, you can't seize the bed, you can't seize the equipment that he used for his job. Those things that you can't seize. So otherwise, you can seize any other property, movable and immovable, any property, if you know the owner. Owner means if the owner is the borrower or the guarantor. But if it is a mortgage, if the case is based on a mortgage, to recover the loan, that you can only seize and auction the mortgage property, not any other property. So that is a difference between a normal money recovery action and a mortgage bond action. So is that clear now?
Yes, sir.
Right. Okay. Thank you. Any other questions? You have any other questions? Okay. If you don't have any other questions, then I'll go to the next one. It's about a legal action on finance leasing. So leasing is another product that we provide to the customers. We have leasing companies, we have banks who are doing leasing. So leasing is a different product which is governed under Finance Leasing Act number 56 of 2000. So it is very important to remember this. Leases are governed by Finance Leasing Act number 56 of 2000, right? So the procedure of recovery under the leasing or leases is given in this act. So therefore, it is important and it must that all the leasing companies and banks has to follow the exact procedure given in this act. So basically, you can't act arbitrarily and take the possession of the vehicle. That is not allowed. If you have not followed the procedure set out in this act, then it is a breach of law. Then you will not be able to get the recover the dues. So therefore, it is very important. So what is the procedure if we take a default lease? What we have to follow? What are the steps that we have to follow? The procedure is this. First, the bank has to send notice of substantial failure. As per the section 21A of the act says that the company has to send a notice of substantial failure. Then afterwards, the bank has to give basically in the same letter that we have to give the customer 7 days to him to rectify or remedy the failure. So when the lease is default, straight away we can't terminate and seize the property or vehicle or whatever. So first thing that we have to send the notice. We have to send a notice to the customer to inform him. Then so him to say that we have basically he has defaulted. There is areas that we have to mention to him. That is called substantial failure. Not only that, we have to give him time, 7 days, to rectify that error or remedy the failure. So then if we pay the arrears rentals, then you can't basically terminate the lease agreement. Then if customer fails to rectify the demand or rather substantial failure notice or substantial failure, then what will happen? The lessee will forced to comply with the terms of the lease requested and accelerated payment. So then we send a letter to the customer and demanding him accelerated payment. So that is the second notice that we have to send. That is under section 20A of the act. So if these both fails, then what will happen? We makes accelerated payment. Then afterwards we send a notice of termination to the customer. Notice of termination that is required under the section 20B of the Leasing Act, Finance Leasing Act. Then after terminating, you have to send the notice of termination. So then afterwards only that we can terminate the agreement, lease agreement. So after terminating the lease agreement, the bank or the financial institution has a right to recover the possession of the vehicle or the instrument. The bank or the financial institution has a right. So section 27 says, with the support of the police. This was a little bit discussed previous recent time, because there was an incident happen. uh, I think it's Nugegoda or somewhere. The finance company, they have taken the position of the three wheeler, and there was a fight, and as a result of that, one person died. So then there was a discussion going on. So basically, what we understand is, most of the time banks and other institutions, that we violate the procedure, because the procedure itself says what is the procedure that we have to follow when we are acquiring the property. The section 21 says, with the help of the police, that we can seize the property. What we have to do is, when the lease is terminated, that we have a right to get the possession. So therefore, we have to lodge a police complaint, and we have to ask the assistance of the police, and we go to the lessee's premises, and we can take the possession of the vehicle or equipment. So that is the one method. The second method is section 28 of the Finance Leasing Act, that provides provisions to get the possession of the lease item through courts. We have to go to courts and file action and get an order, and through the fiscal, that we can get the possession of the vehicle. So police normally they provide service, but if there is a situation where the peace can be breached, then police will not help to get the possession. Then we have to go under section 28 of the Finance Leasing Act through courts, that we can get the vehicle. Then after recovering the vehicle, that we can auction the vehicle, and we can recover the whatever the amount that we receive from the proceeds of the auction, that we can recover. The question here is, so we have a misunderstanding. Sometimes people believe that if it is a lease facility, that if you pay all the lease rentals as per the agreement without any delay, then the leasing company or the financial institution or bank is obliged to transfer the property to the registered owner. So that actually is not correct, because the finance leasing is something different. Finance leasing is different from hire purchase. This is one thing that we have to remember. In a leasing, the customer is obliged to pay the rentals for the period that he used the vehicle. So that is a lease rental. If he pays all the rentals, that doesn't mean that he gets the ownership, or that we are bound to transfer the ownership of the vehicle to the customer. It is not the case. We say we give a lease facility for 60 months, 5 years. So customer can enjoy the lease facility, or rather enjoy the lease instrument, vehicle or whatever the instrument, that he can enjoy the possession, he can enjoy the vehicle, he can keep the vehicle 5 years and use it. So after 5 years, that means after he pay all the rentals, 60 rentals, that he has to hand over the vehicle to the bank or the financial institution. Then the bank or the financial institution, they have a discretion. If they want, they can give the vehicle to the customer, or they can keep the vehicle, or they can sell the vehicle, or they can lease the vehicle to somebody else. So that is very important thing that you have to remember, because our practice is different, but that practice is not required under the law. So then what will happen if customer default? Say customer enter into a lease agreement to pay 50 or 60 rentals. So halfway through, that means he paid only 24 months, 2 years installment. Afterward, customer defaulted. Now, once he defaulted, that we have to follow this procedure. Send a substantial failure, give him notice, 7 days notice to rectify the substantial failure. If he doesn't pay, then we send accelerated payment. Then we even if he doesn't pay, then we go for termination, and after termination repossess the vehicle. So that is the procedure that we follow. So then we say, now we take that example, after 2 years the customer didn't pay. So we seize the property and we then auction the property. So at the auction we say, now we have recovered some amount, but not the entire, the money is due to the bank. The other important feature of a lease agreement, once you enter into a lease agreement, if you are a customer, you remember this, once you enter into a lease agreement, you have to pay all the rentals, whether you enjoy the vehicle or not. That is another thing that you have to remember. Because now, for example, we say now after 2 years that you defaulted, bank seized the vehicle, bank auctioned the vehicle, and then afterwards, as per the agreement, as per the leasing act, the bank is entitled to recover damages also from the leasing. This is very important. I will repeat it. The bank is entitled to recover damages from the lessee. So what is the damage that the bank can ask? The damage is equal to the balance lease installments or rentals. Now, for example, we say customer entered into an agreement for 5 years. 2 years he paid, 24 months. Then after he defaulted. Now we seize the property, we sold the property, and we all recover some money. We say we recovered 2 million. So then we have to give credit to the customer. So then the total amount that we have received from the customer is 24 months installments plus the amount that we receive from the auction. So then you add it, then see how much he has paid. Right? We say altogether he has paid we say it's as example, we say one installment is 10,000 and he has entered into agreement for 60 months. So that means he under the agreement that he has to pay 600,000. Now he only paid 2 months. That means, sorry, he only paid 22 years. So that means 24 months he has paid. So therefore that he has paid 240,000 under the lease agreement. Then we terminated. Now what is the due amount? He has to pay the balance. The balance is 440,000 he has to pay. And we say now we auction the vehicle. We auctioned the vehicle and we recovered another 200,000. So then what is the amount due? We have to deduct that value of the vehicle, or rather the amount that we receive from the auction, from the total dues. That is 440, deduct 200,000, then 240 that he has to pay. That is the rental that amount that he has to pay as a damage. So even after recovering the vehicle, the customer is obliged to pay the damages equal to the balance monthly rentals. That is the procedure with regard to the finance leasing. If you have any questions with regard to the Finance Leasing Act and finance facilities, that you can ask now if you have any questions. Do you have any questions? Do you understand how the leasing facilities are operate, and what is the procedure that we have to adopt to recover a leasing facility dues from a legal? You don't have any questions? Then I will go to the next one, that is legal action on hire purchase. Hire purchase. Hire purchase is little bit different from leases. As I explained you previously, the leases, the ownership of the instrument or the vehicle in a lease agreement will remain with the bank or the financial institution. We call that absolute ownership. Then the user or the lessee, he gets the registered ownership only, not the absolute ownership. So then what will happen after the end of the lease period? The registered owner, that is the customer, has to hand over the vehicle to the absolute owner, that is the finance company. Then afterwards, if the company wants, the company can keep the vehicle and struck off the name of the borrower, or rather registered owner, and the property will become the property of the company. But hire purchase are little bit different. Hire purchase is a single name for this is kuli sinnakkara. So that means that you take the goods under hire with the right or liberty to purchase it. So if you are a customer, you get hire purchase with a right. What is the right? Right to purchase. Right to purchase the goods. So then, what is the applicable law? Applicable law is Consumer Credit Act number 29 of 1982. 1982 Consumer Credit Act. This has been amended several times, but just remember the Act number 29 of 1982. What is the procedure here? The procedure of hire purchase. If customer default more than one installment, right? Installment by the lessee is considered as a default. So definitely it has to be more than one installment. Section 80. So then we have to give 7 days or 14 days notice to terminate the termination to the hire. So depending on the situation, depending on the payment structure, that we have to give 7 days or 14 days. So for example, we say under the hire purchase agreement, the customer has to pay installment every week, weekly installment. So in a situation like that, if he has defaulted more than a single installment, then we can terminate the agreement by giving 7 days notice. 7 days notice. If it is a monthly rental hire purchase agreement, then the situation is if he defaults more than one monthly installments, then the bank or the institution has to rather give notice of termination 14 days prior notice. So you have to give 14 days. So that is the difference here. Then afterwards, after giving notice of termination, if hirer fails to remedy the default, the owner could terminate the hire purchase agreement. So then what will happen? You give notice. So you give a date, 7 days or 14 days. Within that period, the hirer has to remedy the agreement or breach. Remedy means that he has to pay all the due installments, unpaid installments that he has to pay. If he fails to do that, then what will happen? We terminate the agreement. Then after terminating the agreement, the bank or the financial institution can take the possession of the instrument. So there are two methods that we can adopt. Section 90C, owner can repossess. So as per section 90C, the owner, that's the company, can take the possession of the good. Then the second one, section 20 of the section 20, if this is very important, 75% of the higher purchase price is paid, then the company cannot take the possession. This is very important. If the value 75% of the value of the good, if it is paid by the customer by that time, even though he has defaulted the last payments, the bank or the institution cannot basically by their own get the possession of the instrument or the vehicle. So in a situation like that, what is the remedy available? So they have to go to courts and get a court order to seize the goods. So 75%, if it is not paid, bank or the institution can take the possession. If the 75% of the value of the item has been paid by the customer, then the bank or the institution cannot recover the possession. So they have to go to courts and get a court order through the fiscal. Then they can recover the possession of the instrument. Then afterward, the bank, then after seizing the goods, they can auction the goods. So then after auctioning the goods, the bank has to give credit to the value that you receive from the auctioneer or the auction, and afterwards, if there is a balance, the bank then can recover damages. In here, the damages are equal to from the date of the termination to the repossession. So that is the damages that we can ask, not like in a lease agreement, that the damage, quantum of the damage, amount of the damage that we can claim is from the date of termination to the date of repossession, the number of installment that we can recover for this period. For example, we say we terminated the lease agreement in January and we repossess the vehicle in December. So in a hire purchase agreement, hire purchase case, the maximum that we can recover as the damages is 12 months, January to December, 12-month installment, not anything more than that. So this is the hire purchase procedure. You have to compare this hire purchase procedure together with the procedure of leasing procedure. You can see certain differences are there. So you should be by yourself that you have to compare these two and understand the differences. So if you have any questions with regard to hire purchase, you can ask that now. Do you have any questions? Okay, since you don't have any questions, then I'll go to the next topic, that is hypothecary action. What is hypothecary action means? Hypothecary actions, as I informed you before, we file when we have a mortgage as a security, as a collateral. Example, now we say we as a bank, we have granted a loan to a customer. As a security, we have obtained a mortgage. It could be a land mortgage, or it could be a movable property mortgage. So for this example, we take a land mortgage, right? We have a land mortgage. The customer has defaulted. Now, what is the procedure that we can adopt? So when we say land mortgage, we have two procedures. So one is this hypothetical action procedure, that is means through courts that we can recover. The other process is parate procedure. If a loan amount is less than, if the loan amount granted is due amount is below 5 million, then you can't go parate. So therefore, definitely then you have to file an hypothetical action. The first step of the hypothetical action is again sending letter of demand. So you have to send a letter of demand. First is that when you send a letter of demand, you have to remember the letter of demand again. It's especially that we have to demand the amount due from the customer, and also you have to demand the value or demand the dues based on the mortgage. If the borrower and the mortgagor are the same, we send one letter of demand because both are same, and we demand the money as the borrower and also as the mortgagor. We have to demand on the mortgage. If the borrower and the mortgagor are two different people, that means there is an obligor and the mortgagor. So we have to send two letter of demand then. One letter of demand to the borrower demanding money from him, and the other letter of demand to the mortgagor demanding money on the mortgage. And we have to specifically say to the mortgagor that if you don't pay, that we will take steps to execute the mortgage bond and recover the money. So that we have to demand. That is the first step. Then the second step is, if you, after sending the letter of demand, if customer does not pay, customer or the mortgagor, borrower or mortgagor does not pay, if they don't pay, then the next step is we are filing action. Again, we file action. When we are filing action, we normally file the we file the plaint, and together with the plaint, there is a important thing that you have to remember. You have to note down this. Together with the plaint, that we have to file the original registered mortgage bond. Original mortgage bond that we have to file together with the plaint. That is very important point. And if the original mortgage is misplaced, right, then in a situation like that, we have provisions to file a certified copy of the mortgage bond, that you have to obtain a certified copy from the land registry. Together with that, under special circumstances, that party can file a hypothetical action. However, it is the normal process is the procedure that court adopt is, together with the plaint, the bank or the financial institution has to file the original mortgage bond. That is very important to the bankers and also to the others, because if you take a mortgage, it is your duty to keep that mortgage bond, the original mortgage bond, in the safe custody. Because otherwise, what will happen, if you misplace the mortgage bond, then you will be in trouble. If the customer default, that you can't file mortgage bond action without the original. So then if you file action without the mortgage bond, you have to get the certified copy from the land registry. Again, you have to inform both the reasons and why that you have not produced the original mortgage bond. So after filing the action, hypothetical action, see the next step now in a regular action. After filing the case, summons goes to the defendant. But here it's different. When a hypothetical action is filed, the second step or the third step of the case is that we have to file or register a lis pendens. Lis pendens. It's a Latin word, lis pendens. The second step of the case is registering the lis pendens. Lis pendens means it's a notice. It's a notice that we register at the land registry where the mortgage bond is registered. Now, for example, we say customer has a property at Nugegoda and he has mortgaged the property to the bank, and the mortgage has to be registered at Nugegoda land registry. Nugegoda land registry, the mortgage register. Then the list, if we default, then we file action. When we file action, we have to file the original mortgage bond, and also then the next step is we have to file a lis pendant. The lis pendant has to file in the same land register where the records are maintained for the particular land, mortgage land. So lis pendant is a notice. Lis pendant is a notice. Lis pendant normally register in the same folio where the mortgage is registered. So then what will happen? I said it's a notice. It's a notice to the public. Notice to the public who has any interest or any ownership or whatever to that particular mortgage land. So by giving notice that you educate the others that if you have any interest on this property, any right over this property, that you have to lodge your claim in the testamentary action file. So otherwise what will happen later on, that no party can make any application with regard to the mortgage if he has not taken to file papers when the plaintiff file lis pendens. So they have to check at the land registry, then they have to file, then they have to come into the case and they can lodge any claim, whatever they have, right? Then afterwards, after the lis pendens is registered in the folio, then it is a duty of the registered attorney of the plaintiff to go and check the folios of the land registry, right? So then afterwards, he has to give a declaration. The lawyer or the attorney for the plaintiff then has to give a declaration under Mortgage Act. So that under Section 9 of the Mortgage Act. So that is to say that he personally checked the land registry, and if there are any other person to give notice with regard to the land, that he has to disclose that as a declaration. But if there is any dispute or any person who is claiming any right over the property, then in the declaration that you have to reveal so and so is in the occupation and so is or whatever the rather who has registered their rights in the land registry. So the lawyer has to inform the courts, and those people has to give notice under this. So that is the declaration filed by the attorney for the plaintiff. After the declaration is filed, if there are no other parties to give notice, or if they have given notice and they have come to the case, then court issues summons to the defendant. So you can see, not like a normal action, This is some steps that you have to take before you get summons to the defendants. Then after issuing the summons, as a normal case, the defendant will they will get the summons and they have to come and they have to file their answer. After filing of the answer, matter will fix for trial. At the end of the trial, judgment will be pronounced. We say now the judgment is given in favor of the bank, mortgagee rather. Then the next step is the bank or the lender can execute the decree. Execute the decree in a mortgage action is different, not like in a normal action. In a mortgage bond action, when you execute the writ, the plaintiff or the fiscal officer can only seize and auction the mortgage property. Only the mortgage property, not any other thing. Right? So that is very important. The property will be acquired by the fiscal, and then thereafter he will auction the property. He will bring the money to the case, and from there the bank or the financial institution can recover the dues. You can claim the money from the auction proceeds and you can recover the loan. So that is about the hypothecary action procedure. If you have any questions from hypothecary action, mortgage bond action, that you can ask now. Do you have any questions? Any unclear area?
So I have a question.
Yes.
When we go to the mortgage bond auction properties when execute the decree, there is a word called legal interest.
Yes.
What that mean, and can you give me the
right? Okay. Right. Okay. I will explain. Thank you. Right. Okay. Now, good question. Now you see, when we file action, we go to courts and we ask the amount due to the bank. We say the customer has defaulted, and today the dues, as at today, the dues we say 1 million. Loan, capital plus interest, capital arrears plus interest arrears, altogether it's come to 1 million. Then we file action. We have a mortgage and we file action under Mortgage Act, hypothecary action. So then, if you ask 1 million only, what will happen? Normally, this kind of case go over 3 to 4 years. So then what will happen? If you ask only 1 million today, after 4 years, you only get 1 million. Because the reason is the judgment will be given only for the amount that you have asked. But what we do is we ask further interest also. Not only 10 million due, the due 10 million, but we said give us 10 million plus interest till the amount fully paid. So then what will happen? The court will give the 10 million that we asked and also interest. Also interest from the date we file the action to the date that we receive money. So then the question is, at what rate that we can get interest, because the interest rate is not decided now. We have parties have not agreed the rate for the period that we take to recover money. So for that period, court will give legal interest only. Legal interest. Legal interest means time to time the central bank, they issue a circular. In that circular, they mention what is the legal interest applicable during this period. If I remember correctly, in 2017 or 2018, the last circular says the legal interest is 11 point something, 11.5 or 7. So then I believe now it has been reduced. The amount you can recover from a even money recovery action and hypothetical action, the amount you have pleaded in your plaint, and also from the date of the judgment or from the date of filing the case till the money that you recover, you get legal interest on the amount due to the bank. So is that clear enough now? Are you satisfied with the answer?
Yes, sir.
Right. Okay. Any other questions? Do you have any other questions? Right. If you don't have any other questions, we will go to the next one. That is debt recovery special laws. Debt recovery special laws that we are going to discuss. I think we'll have a small break now. Now we are going to discuss about the debt recovery special laws. When we say now all the previous procedures that we discuss are not the special laws, but the laws that we have practiced, procedures that we have practiced over decades, maybe few decades, to recover loans. However, uh, the industry, the institutions, financial institutions, and also the banks, they there was a concern from them. Actually, that is a valid concern. They said the procedures, the normal procedures that we discussed previously, like regular money recovery action, hypothetical action, those procedures are not sufficient, or rather not speed enough to recover the debts to cater to the banking and financial sector. Because now, for example, if I explain this, now we'll see, we say now we grant a loan to a customer. We say it's a short-term loan. We say 3-year loan, 3 years or 2-year loan, 24 months installment that customer has to pay. It's a short-term loan, and we grant the loan based on a guarantee bond. The customer default after 6 months. So then we have to, we tried everything, but then still it is not possible to recover. So then we decide to file legal action. So then we file legal action. You know that we send a letter of demand, then like afterwards we file legal action in district court. So now we file action under under regular procedure. So normally, to get the result, final judgment in a regular procedure case, it takes, my experience, it takes 3 to 4 years. 3 to 4 years. Now, to get the final result, that means execute the decree and get the money, it takes another year or two. So altogether, say 4 to 5 years that you take to get the the final result, or to recover the loan. And the other thing is, even the customer is even the judgment is given in favor of the bank, the customer can appeal against the judgment. That is also possible. If he appeal, the matter will drag further. Now think a situation like this. You give a loan to recover in 2 years time, and customer default after 6 months. Then you file action. It takes another 4 years to get money. So then you can see that you can't survive in the business like this, because the process, debt recovery process through courts under regular procedure is not speed enough to cater to the requirement of the financial institutions and financial sector. So therefore, there was a discussion to have special laws which cater, which is capable to cater to the requirement of the financial sector. So that was the idea behind this, to introduce this new laws, special laws to recover debts. So first, special law that we are going to discuss is Act number 2 of 1990. So it's we have to discuss two special laws under this special laws for this program. You have to remember these two. Easy to remember in this way. Both special laws were introduced in 1990. So 1990 year, both special laws were introduced. So the first one is number 2 of 1990. The second one is number 4 of 1990. Those are the two special laws we have to study for this program. So therefore, remember 2 of 1990 and 4 of 1990. First, we will take the number 1. Act number 2 of 1990. That is, the act is called Debt Recovery within bracket Special Provisions Act. Debt Recovery Special Provisions Act number 2 of 1990. So then we'll see what is the purpose to introduce this act. The act says to provide a speedy procedure to recover the debt through courts. You can see the last two words, it says through courts. So therefore, this procedure also again through courts. Through courts. So then it's a court procedure. Court procedure. However, the first part of this says to provide a speedy procedure through courts, but speedy procedure. So then it can't be the normal procedure that we discussed. Because if you follow the same procedure, then it takes about 4 years. So it's not speedy. So this is a special procedure. Again, the procedure is through courts. So therefore, it has to be something special. Something special, some special procedure that we have to adapt in this. So therefore, what we are going to discuss that later. What is the procedure that we are adapting? So next one, to whom this act applies? To whom this act applies, or rather, in other words, who can file action under debt recovery law? Act number 2 of 1990, special law. So these are it applies to these the institutions and banks. What are those? One, commercial banks. All commercial banks, they can file action under debt recovery law. Debt Recovery Act number 2 of 1990. Then SMIB, they can file action. NDB, NSB is a special bank. DFCC and registered finance companies. So these are the institutions where they can file action against under the Act number 2 of 1990. So that is very important. So you can see the individuals, you can't file action. Individuals are not covered under this. So therefore, they can't file action against another individual or a company. So for example, we say money lender, individual money lender who has lent money, who has defaulted. So then he can't file action under Debt Recovery Act because not coming under the interpretation given there. Then the procedure. What is the procedure applicable? This very important that you have to remember. The procedure adapt here is not the regular procedure. This is the difference. The difference here is the procedure is summary procedure. Very important that you have to remember this. You have to register in your head. It is not the regular procedure that we discuss under the normal normal money recovery action, action against the guarantor, leasing, hire purchase, hypothecary action, all these we discuss. All these cases, the procedure applicable is regular procedure. Regular procedure: file action, send LOD, file blade, file answer, trial, judgment, then execute the judgment and auction the property and recover. So that is the main step of a regular action. But here it is not the regular procedure. It's very important. It is summary procedure. Summary, in Sinhala we call it lagu. Summary. So it is not the lengthy process, then it is summarized. Summarize means it's a shorter version of the regular procedure. It's a shorter version of the regular procedure. So because of that, because the procedure is short, the time taken for the procedure is also short. So compared to regular action, summary procedure action you can finish within 1 to 1.5 years. So compared to regular action, where it takes about 4 years, under summary procedure, recovery action that you can finish within 1.5 years. So that's a comparatively very speedy process. So then there is a limitation here. Limitation is this financial institution, including commercial banks and other institutions mentioned there, they can file action under debt recovery law if the granted loan amount is over 150,000 rupees, not 150 million, 150,000. If the amount is 150,000 only or above only, that we can file action. Otherwise, no debt recovery action you can file under 2 of 1990. Then the next important part is debt. What kind of debt that you can recover under 2 of 1990. That is also that you have to think about, because section 22 of the act applicable here. As per this section 22 of debt recovery special act, only the loan amount, capital dues and interest, normal interest that you can recover. This is very important. Capital outstanding you can recover, and agreed normal interest you can recover. But you can't recover penal interest. This is another thing that you have to remember. Only the capital outstanding and the interest at normal rate. Now, for example, we say we have an agreement. Customer has given a loan, installment, that we say the capital portion of the installment is, we say 10,000, and interest that he has to pay at the normal interest 15% per annum, and if he default or if we delay the payment, that we charge additional 4%. That means 19% we charge as default interest, right? So then if you have charged penal interest, that you can't go under debt recovery, or rather you can't ask penal interest under debt recovery. So what is the amount that you can recover is the amount that, or the rather dues, capital dues under the loan and interest at the rate of 15%, not 90, 15% on the capital outstanding. That is the maximum that you can ask under Debt Recovery Act. That's a section 22 restriction. Then the next important point is this: to file action under this Special Provisions Act, Debt Recovery Special Provisions Act number 2 of 1990, the loan or the facility must be granted on an instrument or on a written agreement. So then if you have to file, if you are to file action under debt recovery, Act number 2 of 1990, you should have a written agreement. You should have a written agreement, or you should have an instrument like post-dated check or promissory note, right? So if you don't have an instrument, or if you don't have a written agreement, that you can't file debt recovery act on a case under debt recovery act. So then you have to file a case under regular action, regular procedure. So that avenue is there, but you can't come to this avenue unless you have a written agreement. So those are the important points that you have to remember before we go into the the procedure, go through the procedure, right? So any questions? If you have any questions from here, you can ask now. Ultimately, for the exam, you will get a question, case study most probably, and they will ask what is the most suitable debt recovery process you have to suggest. So then you have to analyze the case, and then you have to decide what is the most suitable procedure to adopt in a situation like this, whether it's the regular procedure, whether it's a hypothetical action, whether it's a debt recovery action under 2 of 1990, or whether it's parati. So those are the basic things, basic procedures, main basic procedures that you have to look into, and you have to judge what is the most suitable process that you have to apply. So you will not be able to suggest the best option, because all the options are available. You can take all the options. You can choose any option, but any option is not the most suitable option. The most suitable option is there's only one most suitable option. So how to identify, how to choose the correct the process? You have to know the background and the background of the and the law principles apply. Otherwise, that you will not be able to understand or recommend the most suitable method. So, do you have any questions from here? Do you understand what are the limitations applicable under debt recovery law? What are the institutions that you can file action under this law? What is the limitation? What is the amount of the loan? Section 22, the debt. What is the debt, or what is the interest that you can recover? Right? All these things that you have to remember. Right? No questions? Okay. Then remember now, as per this one, as per section 22 says, if it is a loan, you can't loan or any facility that you can't recover penal interest. Penal interest you can't recover. So then remember, if it is a casual overdraft or overdraft, that we charge penal interest. So then it's not possible to file action under debt recovery law if it is an overdraft. And also, if it is a casual overdraft, as we discussed previously, we don't have any written agreement for casual overdraft. Normally, we don't take a written agreement. When we receive the check, we pay, right? So then, in a situation like that, if you don't have a written agreement, you can't file debt recovery act for casual overdraft because there is no written agreement. So in a situation like that, you have to go under normal or regular action, right? So therefore, these things that you have to consider, you have to think about. So then, since you don't have any questions, we go to the process procedure under 2 of 1990. Again, as I told you before, this process is a court process. It's a court process. So first step of the court process, which I have not mentioned here in this slide, that you may remember, the first step is you have to send a letter of demand. Letter of demand. You have to demand the money or dues to the bank or the institution. The first step is that if customer still not adhere to the demand, letter of demand, then you get a course of action against the customer to file action. So we'll say now we send a letter of demand after customer still has not settled the dues. Then what we decide to go under 2 of 1990 summary procedure. Then what is the procedure? First step is send letter of demand. Letter of demand. Then the next step, we file action. We file action. When we say we file action, under this, remember the regular action we file. Remember we file plain plus documents under regular action. These are the things that we file. Plain plus documents, whatever the documents that you have to support your is, we file plain and documents. Then afterwards, you remember court issue summons. However, under the 2 of 1990 process, under 2 of 1990 process, when we are filing action, we have to file this again. You remember this is under summary. We have to file the plain together with the plain that we have to file an affidavit. Then you have to file the agreement, the written agreement for the contract. Then other documents. Other documents that you have to file. So filing, and when you say filing action, these are the documents that you have to file at the first instance. Not like a normal action. In a normal action, you don't file an affidavit, which is very important. You have to file an affidavit, and the written agreement that you have to file, right? Also, you have to file. So these two that you have to file together with the plain in a summary procedure action under 2 of 1990. So then after filing these documents in court, we get a date from the courts to support the matter, support the case. Support the case means the lawyer of the plaintiff, that is the bank, has to present in courts and has to support the case. Present the case to the judge. Now, what are these documents? Plaint is the complaint made by the bank or the plaintiff, and the affidavit is the evidence in written form. This affidavit has to be given by a principal officer of the bank or of the institution. Principal officer means a manager or above. A ranker has to give the affidavit. And then the agreement, the original agreement without any alteration, that we have to annex. And other documents to support the plaint. Other documents means, example, account statement, loan repayment schedule. If it is routine, the loan is routed through a account, the statement of the account. So those things that we have to annex to the as documents to the plaint to support the story we have mentioned in the plane. So these are the supportive documents to support the plane. Now after this, the lawyer appear in courts on the particular given date. Normally, once we file action, we get a date to support. We get a date within 1 month's time. We say within 1 month's time to support the case. Then the lawyer will support the case. Support in the sense present the case to the judge. So judge, after hearing the submissions made by the lawyer and after perusing the documents and the plate and the affidavit given or filed in courts, if judge is satisfied with the documents and the submissions, the judge will issue a temporary judgment called order nisi. This is called order nisi, right? Order nisi is a temporary judgment. It's a temporary judgment, right? Not a permanent judgment, temporary judgment. So once the order nisi is issued, this will be served to the defendant. So order nisi will be served to the defendant. By register post, the order nisi will be served to the defendant, or through the fiscal it can be served. So then once the decree nisi is served to the defendant, that this is the borrower, right? That is the notice given to the borrower. So what is the notice says? Notice says there is a case filed against you, and court has given a temporary judgment against you. If you have any reasons to show courts that why should the court not convert this temporary judgment into a permanent judgment, you should come and show your cause on such and such a day. That is the notice given with the service of decree nisi to the defendant. So then defendant, then after serving the notice, he has to seek permission from courts to enter into the case. So basically, now you can see in a regular action, we send letter of demand, we file action, then summons served to the defendant, and once the summons is served, the defendant can come and he can file an answer. That is a right. But here, as a right, the defendant can't file their answer. So before that, they have to get permission. Get permission. So therefore, they have to file their papers. They have to file their proxy and objection and affidavit. They have to file. So after perusing these documents, court can decide two things, right? One, we say court satisfied with the documents and the objection what they have taken. Court is satisfied with the defense taken by the defendant. So therefore, in a situation like that, court will grant permission to the defendant. Court will grant permission. So if court does not satisfy with the objection or the reasons given by the defendant, then court will refuse. Will not grant permission. Grant or not grant. If permission is granted, then what will happen? Then the matter will fix for inquiry. Inquiry. Right? After the inquiry, two things can happen. Right? If court still believe the NICI order issued by the court should be made absolute, then court will make it absolute. So court will make it absolute, right, after the inquiry. If permission is not granted, immediately the court will make the order NICI absolute. This is the procedure under the summary procedure under 2 of 1990. So then, after making the decree absolute, that is the final judgment, then we can go through the process and execute the decree, seize the properties, auction the properties, and then recover the loan. That is the procedure under 2 of 1990. So, do you have any questions under this process, about this process? You understand the process? Do you have any questions? You don't have any questions? Okay, then I'll go to the next one. Right. So then I'll go to the next one then. That is the process called Parate procedure. Parate procedure. 2 of 1990 is about recovery of loans through court case. And we adopt summary procedure. Parate procedure is different. Parate procedure is different. Parate procedure, under the Parate procedure, banks can recover their loans. Listen very carefully. Banks can recover their loans by auctioning or by selling the mortgage property without going to courts. Again, I will repeat. Listen very carefully. Under the Parate process, banks can recover their loans by auctioning or by selling the mortgage property. Mortgage property. Now this is a special law. Now forget about the special law. Tell me, if you are a bank, if you have a loan secured by a mortgage, what is the procedure that you have to adopt? If this special procedure is not there, what is the procedure that you have to adopt? Can someone answer for this question? Say you don't have Parate procedure, but you have a loan backed by a mortgage bond. Then what is the procedure applicable?
Mortgage action.
Very good. It's a hypothetical mortgage action that you have to file action in courts. Through court process that you have to recover. Now, this process is a special process introduced by the legislature in 1990 to auction the mortgage property to recover the loan. Now we have two lines, two parallel lines. One side we have hypothetical action where you go to courts, you get a judgment, and the fiscal auction the property and bring the money and settle the bank. That is one procedure, one process, hypothetical action through courts. From the other side, we have Parate procedure. Under the Parate procedure, the banks itself auction the property and take the money and recover the loan. So these two pillars are there. Now, when when a loan is granted, and when a loan is granted and the loan is secured by a mortgage, and if it is default, we as a bank has to decide in what cases. Basically, first thing that we have to clear about whether we can go parate for any mortgage loan if it is defaulted. Right? First thing that we have to understand, we have to be clear, if a loan is secured by a mortgage, can we go parate for any loan if it is backed by a mortgage? Right? Or do we have to go under hypothetical action for certain cases? In other cases, you can go parate. So remember this thing, all mortgage loans are not subject to parate. So basically, in other words, if it is a loan, if it is default, if it is backed by a mortgage, every mortgage loan can't go parate. Some you can go, some you can't. You can't mean then you have to go to hypothetical action. Go for hypothetical action. That you have to be very clear about it, because you have for your exam you will get a question or a case study, then and after analyzing the case that you have to decide whether you want to adapt the hypothetical action or mortgage bond action, or whether you can go parate. You have to judge and you have to decide. So if you judge wrongly, then your entire answer will be wrong. So then you will be in trouble. So therefore, listen very carefully and understand for what cases that you can go parate and for what cases you have to go hypothetical action. That is the requirement here. Now, I said the parate procedure is a special procedure. Special procedure means that is a alternative or special thing that introduced to the normal thing. Normal procedure is the hypothetical action in courts. So here, the parate process is not a court procedure. That is a main difference between these two. Hypothetical action, court procedure; parate action, not a court procedure. The title of the act says Recovery of Loans by Banks Special Provisions Act number 4 of 1990. So when you read the title, you can get a big idea, right? Why it says the purpose it's mentioned, recovery of loans by banks. So therefore, you can follow this process, adopt this process only to the recovery of loans. No other purpose. So in other words, if I say simply, by using the parate procedure, bank can't get the ownership of the property. So this is not a procedure to acquire properties, right? So bank can't acquire the properties using this procedure. You can acquire the properties, but for a short period of time. You have to alienate, you have to sell it and recover the loan. So purpose is to recover the loans. That is the first thing that you have to see, you have to remember. The name itself says so. So recovery of loans. Then the next word, by banks. So it is specifically says the act is applicable only to the banks. So the financial institutions, individuals, it's not mentioned here. So therefore, this act is only applicable to the banks. So that is that your banks means licensed commercial banks. Licensed commercial banks. So that you have to remember. Apart from this parate process, apart from this 4 of 1990, certain state banks and other institutions also given parate power. For example, Bank of Ceylon, they have parate power. Their parate power is given under the Bank of Ceylon Act. So likewise, People's Bank also, they have parate power. Their power is given under the People's Bank Act. Likewise, different institutions, or rather banks, have been given the power to auction, power to parate under their act. This is an act given or passed by the parliament to give the authority or the power for parate for the commercial bank, private commercial banks. So that is, you have to remember. So what are the things now you have to remember? This is not a court procedure. This is a non-court procedure to recover loans by auctioning the property. Bank itself auction the property. That is the first thing that you have to remember. And the name of the act is Recovery of Loans by Banks Special Provisions Act. So this act only can be used to recover loans, not to acquire properties. And it is only applicable, this act is only applicable to the commercial private banks, right? Those things that you have to remember. Then afterwards, what is the purpose of the act? Purpose also mentioned there. An act to provide this recovery of loans granted by banks. That is the purpose. This act is enacted in order to recover the loans granted by banks. So therefore, other financial institutions are excluded. So they can't utilize parate, or they can't use this parate procedure to recover their loans, even though if it is secured by mortgage. So they have to go to courts and file MB action, mortgage bond action. Then the procedure I have given here, it's not a court procedure. It is the procedure in the control of the bank. So these things that you have to remember. Keeping that in your mind, then we'll go to the procedure. Any questions from the previous slide? This one, any questions?
Is there any examples that you can give for parate procedures?
Can you little bit explain to me what area
what type of loans, like as in what type of recoveries can a bank go through the parate procedure?
Right. Okay. May I know your name, please?
I'm Melisha.
From
NDB.
Okay. Right. Melisha, no?
Yes.
Melisha, I am going to discuss later, because that is covered under my presentation. What type of loans we can go parate and what type of mortgages are subject to parate, we are going to discuss at the end of this procedure.
Okay.
Right? Okay. So after that, if you still you have a doubt, then you can I will explain further, right?
Sure. Okay.
Okay. Right. So then we'll go to the procedure then. Right. Any other questions other than that from this slide? Are you clear? Right. Okay. Then I'll go to this one. Right. What is the parate? What is the process? First one, as we knows, the first step of any legal action or any parate, any recovery action, the first thing that we have to send a letter of demand. Letter of demand that you demand the officially, or rather legally, that you demand the amount, whatever the amount that you claim, that you have to demand from the customer. So you send a letter of demand, first thing. Then we give 14 days, customer won't settle, then you go for the next step. After sending the letter of demand, if customer still doesn't settle the loan, then the next step, director board of the bank passed a resolution. Director board of the bank pass a resolution for a purpose. What is the purpose? By passing a resolution by the director board can appoint an auctioneer, or they can appoint a manager. Right? Listen very carefully. right? The first step is to pass a resolution. Pass a resolution. Now, this whole purpose of the act is to recover the loan. Now, bank send the letter of demand. Customer didn't reply or customer didn't pay. Now we are going to recover the loan. How we are going to recover the loan? We go for the second step. Second step, the director board of the bank pass a resolution. We have a mortgage, and now we are going to recover the loan through by selling the mortgage property. So now director board of the bank can pass a resolution. By the resolution, they have option. They can do two things. One, they can appoint an auctioneer, or they can appoint a manager. So I'm sure most of you are aware that the bank can appoint an auctioneer. And the second part, or they can appoint a manager. I'm sure most of you are not familiar with that. Why we are appointing a manager? First of all, tell me, by appointing an auctioneer, what do you expect? Can anyone explain to me?
To ensure transparency?
No, my question is this. By you're appointing now board of the directors can appoint an auctioneer or manager, right? Right. So my question is, why do you appoint an auctioneer? What is the purpose? What are you going to do with the auctioneer?
To auction the property.
To auction the property in order to recover the loan.
Yeah.
Right? Then the next question is, why do you appoint a manager? Do you have any idea?
No.
May I know your name?
Seller.
Asela. Okay. Asela, now the purpose of the procedure is to recover the loan. So you agree with me? Right, Asela? Right. So then you appoint an auctioneer to auction the property and recover the loan. That's the first part. The second part says you can appoint a manager. So by appointing a manager, what is the goal you are going to achieve? Again, you have to recover the loan. So auctioneer auction the property and recover the loan. Manager manage the property and recover the loan. Clear? I will explain that, right? Now think a situation like this. We say we have granted the loan and it is backed by a mortgage. We say it's a residential property, 20 purchase land and a building, mortgage to secure the loan. First scenario, first case, right? And he has taken the loan and has defaulted. And in a situation like that, the bank now can pass a resolution and they have two options. One is to appoint an auctioneer. Two is to appoint a manager. What is the best option that you think the bank should adopt here? The best option in a situation like that, to appoint an auctioneer, because the property the mortgage property can be easily sold, because 20 purchase residential property you can auction, or you can after auction you can resell easily. So you don't want to manage the property, you can auction the property and recover the loan. That is the first. Take another case, a scenario like this. Say you have granted a loan to a tea factory, right? Tea factory. And this tea factory, it has, we say, 700 acres of tea. And they have employees, they have few tea factories. It's a tea, we say tea company, right? It's a company and they have tea factories, they have machines and everything in this, within this mortgage property. In a situation like that, if now you have to think, you have two options. One is that you can appoint an auctioneer and auction the property, and two, second option is that you can appoint a manager and manage the property and recover the loan. We say now, what is the best option that you think? You have to analyze the situation and you have to decide what is the best option. So in the second scenario, if you appoint an auctioneer to auction the tea factory and the tea estate, you will never sell a tea factory in an auction. It's not possible. So therefore, if you think, and after analyzing the feasibility, if you think that by managing the property, the tea estate, that you can recover the loan, so then the best option is to appoint a manager. So therefore, you appoint your manager to manage the mortgage property and generate income, and from the income, the manager can settle the loan to the bank. So those are the two options available to the bank when they are passing the resolution. Any questions? Do you understand the situation? Asela?
Yeah.
Clear?
Sir, can we appoint a third party as a manager? Third party company or
Yes.
third party?
Right, good question. Yes. Now auctioneer is a definitely third party, right? And also manager also can be appointed. A third party also, a third party can be appointed as a manager by a resolution of the bank. A reputed, a qualified person you can appoint as a manager. Clear? Is that clear, Asela?
It's Champika. Can we appoint a firm, not individual?
Yes, that is possible. Yes. For example, there are service providers, right? You may have seen a accounting firm that you can appoint,
Yeah, I think so.
right? So likewise, that you can appoint, that is possible, right? Best thing is to appoint an actually a firm, not an individual, right? As a is that clear now?
Yes.
Okay, right. So then after so for the time being, we forget about the manager, because after appointing the manager, there is no other provisions that you have to go through. The manager has to manage the property and generate the income and pay the loan. After settling the loan, then the manager has to give the management to the previous the owners, and he can get away from the after collecting his fees and everything, that he will be released from the job. Now that is the second part. We'll take the first part, that is to auction the property. So we say now the bank, by passing a resolution, appoint an auctioneer. After appointing the auctioneer, next step is notice of resolution. Notice of resolution prepared by the bank. Notice of resolution, after passing the resolution, the board, after passing the resolution, we have to publish the notice of resolution in the government gazette and 3 newspapers in 3 languages. The bank has to publish that. So then that is the third step. After that, up to that point, the bank has to take all these steps. Then after that, the next step, auctioneer has to take. That is, after publishing the notice of resolution, we have to dispatch the notice of resolution or copy of the notice of resolution to the borrower. We have to pass the resolution, we have to publish the notice of resolution in the government gazette and also in 3 newspapers in 3 languages, and we have to give notice to the borrower. Then our part is over, bank's part is over. Then the next step onwards, the auctioneer has to take. So that is 5th one. The step is notice of sale. Notice of sale. That has to be prepared by the auctioneer. Auctioneer has to prepare the notice of sale. So what are the things should be included into the notice of sale? That is the date, the time, and the place of the auction. He has to mention in the notice of sale. You remember the sale is a public auction. So therefore, he has to give notice to the public. The auctioneer has to give notice to the public. So he has to mention the date, the time, and also the place that he is going to held the auction. And it has to be published in the gazette again. And also in notice has to be given government gazette, and also he published the notice in the newspapers also in 3 languages. And notice should be given to the borrower, and also the notice and the banners has to posted on or near the property. Important thing is he has to do this before 14 days of the auction. Before 14 days, he has to take all these steps. Notice of sale has to be gazetted, has to be published in newspapers, has to be posted in the property or the other property, and copy of the notice of sale to be given to the borrower. So that is notice of sale. After that, the next step is, now the auction is, date is fixed, notice is given. Then the next step is upset price. Upset price. Upset price means the price that we know it's a public auction. At the auction, that the auction start at a point. Now, for example, we say the auctioneer has to start the bidding from a point or from a value. That is the minimum value that the auctioneer can sell the property other than to the bank. So no one else can purchase the auction property other than the bank below the upset price. So therefore, the bank has to decide what is the upset price that we are going to quote. That has to be decided by the bank, not by the auctioneer. You have to remember that. Board of directors has to decide. Board of directors has to decide what is the price that we are going to quote as the upset price at the auction. So the board of directors has to fix the upset price below which the property shall not be sold to any other person other than the bank. Now, when we say the board of directors has to decide, basically the bank officers has to decide this, and they have to present a board paper to the board, and board they don't decide on this, they just pass the board paper. So then, as a bank officers, you should know how to prepare and what are the things that we have to consider when we are preparing upset price, because this is a one place that a customer can challenge, that the borrower can challenge. They can go to courts and get an order to stop the auction if you are going to sell the property for a lower value. So therefore, you have to consider certain things. What are the things that we consider when we are fixing upset price? First thing that you have to remember, before we decide the upset price, we have to get a valuation report, a proper valuation report that we have to obtain. The valuation report, as you know, in the valuation report, it gives the market value of the property, for sale value of the property. So those two things that you have to consider. And also that you have to consider the total outstanding or total dues of the customer and expenses. these three that you have to consider. What are those? That is market value of the property, for sale value of the property, and the total outstanding of the customer. Based on these three, that you can fix the upset price to the market value or to the for sale value or even to the total outstanding. So for example, we say the total outstanding of the customer is 7 million, but the market value of the property is 10 million. For sale value is, we say, 9 million. In a situation like that, if you fix the upset price for 6 million, the customer will go to courts, and then the customer will challenge that decision of the bank, because as per the Act number 4 of 1990, after we recovering our loan, the excess money that we have to return to the borrower. We have to return to the borrower. So that means in indirectly it says that we have to get the maximum to the property. We have to get the maximum to the property, and we have to recover whatever the dues to us, and then we have to return the money to the borrower. That is the idea. So therefore, if market value is high, outstanding is low, it is not prudent to fix the upset price for the outstanding. So best thing is best practice is fix the upset price for the for sale value. That is the most safest thing to do. It's very good if it is very safe that if you can put the market value, but the problem is then you will not be able to sometimes sell the property, because people will not buy properties at that price. For sale value, that is in between. So therefore, the most safest thing to do is fix the upset price at the for sale value. Then after fixing the upset price, the bank has to inform the auctioneer the upset price. Then on the due date, the auctioneer will carry out the auction. Then at the auction, we say there are bidders, right? There are bidders. Then the successful bidder who gives the highest value at the highest bid at the auction will get the property. So if we get the property at the auction, then the auctioneer and the buyer will sign a document, an agreement. That agreement is called condition of sale. And it is a document, agreement, a written agreement attested by a lawyer or notary, and it has to be registered also. Then what is that agreement? Now, as we know, when we go to auctions, we don't take money to the auctions. So then when we are buying the property, we enter into a condition of sale with the auctioneer. In that condition of sale says what percentage that you have to pay at the auction site, then afterwards how you are going to pay the balance. So basically it's a payment plan. So then after the bidder entering into the condition of sale, the bidder has to pay the balance money as per the condition of sale. So then if he pay the money as per the condition of sale, the bank will issue him a certificate of sale. That is the deed. That is the deed that he get the title to the property. The buyer get the title. That is when there is a bidder. Now think a situation where the bidders are not there. If bidders are not there, then the bank officer on behalf of the bank can bid a nominal value to the property. So then after that, after bidding that, the property can be acquired by the bank through the agent, that is the bank staff. Then if it is acquired by the bank, the relevant officer, representative of the bank, and the auctioneer has to sign the condition of sale. Then after acquiring the property, board of directors, they issue a certificate of sale confirming the property being transferred to the bank. When I say this, when it is acquired by the bank, it doesn't mean it becomes a property of the bank. Bank hold the property, acquired property, for a shorter period of time. So next step in a situation like that, the bank has to find a buyer within a reasonable time and has to resell the property to the buyer and recover the loan. If there is excess money after recovering the loan, that has to be returned to the borrower. Once, if the property is acquired by the bank, then if you find a buyer, bank issue a document called endorsement. That is it's like a transfer deed. Then the new buyer will get the title to the property by this deed. So then after that, recover the loan and return the surplus to the borrower. That is the procedure. Any questions from the procedure? You have any questions? Unclear point on the procedure?
Yes, sir.
Yes.
This is a procedure if we appoint an auctioneer. If we appoint a manager, what is the procedure? The manager of
Okay. If you appoint a manager, what is the procedure? That's your question, right? Okay. So as I told you, once you appoint a manager, the manager's duty is to run the business, create the generate the income, and pay the loan. And after paying the loan and recover his fees, that his duty comes to end. So thereafter, actually you don't have to go through this entire process. Nothing. Basically, you appoint an auctioneer, appoint a manager by a board resolution. Then manager goes and take the possession of the property. Then he put his staff there and run the business. Then bring the money, route the money through the accounts of the bank and settle the loan. After settling and after recovering the fees or charges, then after that his part comes to end, and then thereafter bank, by passing a resolution, again will hand over the property to the borrower. That is the procedure. Are you clear now?
Yes, sir. Yes.
Right. Okay. So any other questions with regard to the procedure? Okay. If you don't have any questions on the procedure, then we'll go to the next slide. Now, remember, I said under the Parate procedure, I said before I start, when you have a mortgage property to secure a loan, you have to decide in what cases that you can go Parate, in what cases that you have to go for hypothetical action. So that you have to decide based on the facts of the case. Now remember, the Parate procedure, at the beginning there was no restrictions on the main act. That is number 4 of 1990. When it was passed, there was no restrictions. However, afterwards there were 2 amendments came to the main act. That is in 2011. Both amendments came in 2011. As a result of that, now there is a restriction. There is a restriction introduced to the main act by an amendment, 2 amendments rather. So what are those amendments? Act number 1 of 2011, amendment number 19 of 2011. Those are the amendments. So I will just tell the background of these 2 amendments. This is during, I believe, the Chandrika Kumaratunga's period. There was a concern. Now, when the Parate procedure was given, Parate powers were given to the banks, they started auctioning the property through Parate process when the loan is default. Now, irrespective of the loan amount, even for housing loans, small scale businessmen, everyone's properties were auctioned under Parate. So then in this era, there was a concern. This was the procedure that they said that this procedure was arbitrarily used by the banks. So it was not good for the small scale businessmen and individuals. So therefore, there we should apply some limitations to the procedure. Parate procedure, we have to restrict the Parate powers of the bank. So therefore, at that time, the legislature introduced these 2 amendments to the Act. So Act number 1 of 2011 and Act number 19 of 2011. So what is the restriction applied now or introduced by these 2 amendments? So as per the amendment, now amendment said no action to be initiated to recover of any loan in respect of which the default is made where the amount of such loan is less than rupees 5 million. This was the initial amendment came 2011 number 1. So then you can see after the amendment, if the granted loan amount is less than 5 million, the bank can't auction the Parate property. So auction the mortgage property under Parate. So therefore, then what you have to do, you have to go to courts and file hypothecary action. So that was a restriction. However, now when you read this amendment, this paragraph, that is number 1 of 2011, now there is a doubt now. There is a unclear area. Now it says, no action shall be initiated to recover any loan in respect of which the default is made where the amount of such loan is less than rupees 5 million. When we say the amount of loan is less than 5 million, then there was the concern whether what is referring here, whether it is the granted loan amount 5 million or whether the outstanding is 5 million. Then it was cleared by another amendment, that is amendment number 19 of 2011. As per that amendment, it says if the outstanding amount is, if the granted loan amount is below 5 million, then you can't go Parate. So basically, the restriction implied here is if the granted loan amount is below 5 million, as per the amendment number 1 and amendment number 19 of 2011, bank can't go Parate. So that is the first restriction. However, what is the present situation? That was again reviewed in another case recently in 2017. Sumudu Sanjeeva Nanayakar versus HNB and others is the case. I have given reference here, but you don't have to remember the reference, but you have to remember the case. Name of the case. Sumudu Sanjeeva Nanayakar versus HNB. In this matter, it was argued again in courts, in the Supreme Court, and the same argument came again. Whether it is by the amendment, what is the intention of the legislature? Was it is it the total outstanding of 5 million, or whether the granted loan amount is 5 million? That was the argument brought before the Supreme Court. Now think a situation like this. Now, as per the amendment, we say if the granted loan amount is over 5 million, if it is defaulted, bank can go parate. So that's the interpretation given earlier. If the granted loan amount is over 5 billion, if it is defaulted, we can go parate, or the banks can go parate. So now think a situation like this. Bank has granted a loan, 6 million loan. So then it is obviously over 5 million. If it is defaulted, bank can go parate as per the interpretation. Now we say the customer has paid a major portion of the loan, right? We say now he has paid as example, we say he has paid 5.9 million. 5.9 million he has paid, right? And the last installment defaulted. Whatever the reason, the last installment defaulted. Now, if we go strictly, if we adapt the interpretation strictly, still bank can go parate. Now you see, granted loan amount is over 5 million, that is 6 million, bank has granted, and the last installment customer has defaulted. So therefore, bank under the provisions of Parate Act, we can go parate. So that was the idea before. So, however, that was challenged in this matter. Sumudu Sanjeevananayakara versus HNB matter, that was challenged. So they said, in a situation like that, the bank has given a wide authority or wide power, where they exercise that power arbitrarily, which is not good for the customer. So therefore, they argued it is not the case. It has to be granted loan amount has to be 5 million, and also dues also has to be over 5 million. That was their argument. So ultimately it was held by Supreme Court. Granted loan amount and also the balance dues also has to be over 5 million, that to adopt the Parate procedure. Now the situation is that. Then the next one is, next restriction is third party property mortgages. Third party property mortgages. So this again, in the initial stages, under the Parate procedure, banks, we auction every property mortgage to the bank, irrespective of who is the owner. Now, for example, we say A obtained a loan, B mortgage his property as a collateral to obtain a loan to A. So that is clearly third party mortgage. So if A default the loan, bank under the Parate auction third party property, B's property we auction. So that was challenged in Chellaiya Ramachandran versus HNB matter. Chellaiya Ramachandran matter, what happened? Borrowers, this Chellaiya Ramachandran's property was mortgaged to obtain a loan to somebody else. So then bank went to auction the property, and Chellaiya Ramachandran filed action against that, and he challenged that. He said, under Parate Act number 4 of 1990, the power to auction the property, third party properties, has not been given to the banks. So that was their argument. However, after analyzing all the provisions of the Act, the Supreme Court decided, as per the provisions of the Act, the bank has no right to auction third party properties. So therefore, now the present situation is bank cannot auction third-party mortgage properties under parati. If it is a third-party property, then you have to go under hypothecary action. Then the second case, Samathapala Jayawardena versus HNB and Samathapala Jayawardena versus Sampath Bank. Both the cases, the facts are same. What happened in this matter? It was a family business. It was a family business. Father, mother, and the son were the shareholders of the company. Father is the managing director, main shareholder of the company. Other two were silent directors. They had only one share each, I believe. And the property of the mortgage property was owned by the managing director, Mr. Samathapala Jayawardena. What happened here? The company took a loan from the bank, and the managing director, who was the main shareholder, 98 shares held by him, mortgaged the property as a security for the loan. So then the company defaulted. HNB went to auction the property under parati. In that situation, Mr. Samathapala Jayawardena went to courts, and he quoted Chellayya Ramachandran case also, and he said this is clearly a third-party property, third-party mortgage. So therefore, bank cannot auction the property as per the Chellayya Ramachandran judgment. So if we analyze the argument of Mr. Jayawardena, Samathapala Jayawardena, his argument is it's a I would say correct argument, because a company is a legal entity, and Samathapala Jayawardena, the owner of the property, is another natural person. These are not the same. So therefore, technically, it's a third-party mortgage. However, in this case, something special happened. So in this case, the Supreme Court analyzed the entire facts, and then the judges of Supreme Court realized, even though the loan has been given to the company, the beneficiary of the loan is not the company. Actually, it is the same Samathapala Jayawardena, because he is the managing director. He holds 98% shares, and he controls the company, and he has utilized the loan as he wished. Now, when the bank went to auction the property, now he is hiding behind the corporate veil and says, look here, I am not the person who has obtained the loan, it is the company. So therefore, a property belongs to me, company is the borrower, I am only the obligor. So therefore, this is a third-party mortgage which cannot be auctioned under parati. That was his argument. But there is a very famous English case decided in English. Case was Salmon versus Salmon. In that case, there is a principle called lifting of corporate veil. So that means when a dispute arises like this, the court can lift the corporate veil of the company and see who is actually operating the company. That is called lifting of corporate veil. So the Supreme Court of Sri Lanka applied the principle of Salmon and Salmon, decision given in the Salmon and Salmon, and decided in this matter, if it is a loan given to a company where the property belongs to a director like this, and if that director has been benefited from the loan, that Salmon and Salmon theory applies, and the court will lift the corporate veil, and in a situation like this, those kind of mortgages are subject to parati. So that is the second decision given by the Supreme Court. And again, I am telling you, by Samathapala Jayawardena matter, the Supreme Court never said the bank can auction third-party properties. That law is still valid. Chellaya Ramachandran judgment is still valid. It is not overruled by Samatha Palajavardhana matter. Samatha Palajavardhana case, court took a different point of view, that is about lifting of corporate weight. Right? Then the next one, recent case, Mudita Perra versus DFCC matter. So in this matter also, the recent case, it refers to the previous matter, Samatha Palajavardhana. Here what happened, again the loan was taken by a company, a director has mortgaged the property, and DFCC went to auction the property when company default. On the basis that the director has benefited from the loan. So therefore, as per the Samatha Palajavardhana judgment, bank is entitled to auction the property under parate. However, in this case, what happened? There was a clause in the mortgage bond to say the benefit of the loan or the directors of the company should not get any benefit out of the loan. That there was a condition like that. Not the same wordings, something to effect to that was there. So that shows that the directors of the company has not got any benefit of the loan. So therefore, it was decided here in this case, when a director is not benefited from the loan given to the company, the bank has no right to auction the property under parate. In a situation like that, you have to go through the hypothecary action. So that is about parate process and limitations. So that is the end of the special debt recovery laws. Now, you have any questions with regard to the limitations of parate or anything with regard to parate, you may ask now. Do you have any questions? Anyone has any questions? Are you clear about the Chellaya Ramachandran matter, Samatha Palajavardhana, Mudita Parra case, and amendment number 1 of 2011 and amendment number 11 of 2011? So 19 of 2011. And also Sumudu Sanjeeva Javardhana, Sumudu Sanjeeva Ranayakar versus HNB. Any questions? Okay, since you don't have any questions, I will stop at this point. I have circulate the next topic also, that is securities. So we'll start the next lesson on the next next Sunday at same time 1:15. Thank you very much for your participation. If you have any questions, even next day that you can ask, and read your materials and be prepared for the next lesson. Thank you very much.